Hey, what's up guys? Today we're going to talk about the rights of buyers of private properties that have not been completed and then the developer goes bankrupt. The Singapore High Court in the recent case of J Machinery Private Limited and Astoria Development Private Limited had to decide on this issue. What happens to the buyer's money when the developer goes bankrupt? The High Court held that buyers had acquired an equitable proprietary interest in the development site, ranking below the bank but above unsecured creditors. What are unsecured creditors? That means people who have claims against the developer but are not secured. That means subcontractors, because there's no security interest in it. What is equitable title? Equitable title means on paper they are not the owner, but they have the right to obtain full ownership of the property or right to use the land and property and enjoy the benefits that come along with its ownership. An example would be a bank, lending money to a borrower to buy a house. So therefore, the house is mortgaged to the bank. So on paper, the bank owns the house, but the home buyer, the person who bought the house, has equitable title. Only when he repays the money to the bank in full, then he acquires legal title. When the property is paid in full and the bank gives him back the title deed, then he becomes the legal and equitable owner. So as I mentioned earlier, in the case of developers that go bankrupt, the buyers of the property do have an equitable proprietary interest in the property that ranks above unsecured developers. Why? Because purchasers of units from licensed housing developers enjoy special protections and privileges under the Housing Development Act. As provided for in the Housing Development Control and Licensing Act, all sums paid by the buyers under their sale and purchase agreements are protected against the general unsecured creditors of the developer and can only be applied towards specific purposes relating to the building project. In fact, such sums of money that have been paid to the developers are not considered to be the property of the developer under the Housing Development Act. Furthermore, in the terms of the sale and purchase agreements, which are prescribed under the Housing Development regulations, the rights of the buyers under the sale and purchase agreements are regarded as having priority over the unsecured creditors of the developer. The court also accepted that the buyers in this case, while having no legal title in the property until completion — legal title means on paper you have you have title to the property. So even though they did not have legal title to the property until completion, they did acquire an equitable proprietary interest in the development site, which may be protected by the lodgement of caveats. Under the Building Maintenance and Strata Management Act, every sale and purchase agreement for a lot in development incorporates a term that the purchaser had purchased an undivided share in the land on which the development is to be constructed, which clearly confers a proprietary interest, a property interest. The court also noted that it is common practice that upon execution of the sale and purchase agreement prescribed under the Act and the rules, a buyer can lodge a caveat against the unit in question that he bought, even though no strata titles have been issued yet, the certificate of title. So, the Singapore courts have recognized that a purchaser has a caveatable proprietary interest in the land upon which the development is to be constructed. So thanks for watching this video on the rights of buyers in uncompleted developments.